Kwabena AduBoahen in a court case and matters arising. Gossip Politics TV. So unsubscribe, subscribe now, hit it on the notification bell. So send any update be able dropping also onsa ebe to me. Akabi eba be dwedwam na abusuan sa na ye be dwedwam no. Abusuan say open prepaid credit and as a card to abora suitable needs ventures. Suitable needs ventures. Abusuan baby a wo bia no. Unya frɛ number ye gu screen so a emfa ho ne location obe send o prepaid credit and o card dia there and the amount free 0595696588 0595696588 ho and I just say nyina ye to ye prepaid credit and the every moment bonra eye yensem Kwabena AduBoahen in court case and matters arising embre bi on the lawyers edwane koto appeals court application on the court no court no ebo edit to go ya Echrom say almost so call high court na the court proceedings no enkoso na ene ye ho na appeals court asanso de order bia ba appeals court order AttorneyGeneral&EOCO say omonfa omo evidence against Kwabena AduBoahen omonfa mbra bonten omon bie mu na ye hu say fair trials na ye den enkoso no after say Kwabena AduBoahen omodwane ko to appeals court the appeals court nso asanso the aba no ntino Yoko any Attorney General office omo be produce the evidence against Kwabena AduBoahen money transfer from a National Signal Bureau as is here enye asemketo akra amom yenko na yenkonkotie ensema e course na ansa na be kono me pese menemo edi enkomo bi ewa ha say abusuya Ghana ha open computer papa and as a laptop papa no we use abura periodic computers and accessories eba say ukra low budget ukra high budget obema high quality laptop na we use using the eba location na enye problem free number ya egusu 0247 030188 and I say 0597 942133 so offer some numbers too na uenya periodic computers and accessories are free 0540 882-824 periodic computers and a laptop papa if yen so or provide your laptops are yen so you use your own say I don't know a quality so friend ubenya on the location or Kumasi Wokum Estate Ela and a periodic computers mommy and corner yen konkuti and some of course
to these individuals and what they say is incapable of performance. There's an exercise in jest.
Somebody like Abronye, DC?
What does Abronye said, which is subversive of the Constitution of Ghana? If a man is bold and is able to express his feelings concerning certain issues and you disagree, let's hear your disagreement. That is the beauty of democracy, that we might not agree. Even right in this studio, we might not agree. But the power of democracy is that we can engage in free speech. What I say, you can counter, and then we express it and go. It's not clubs and asega. It's not using arrest to intimidate people so that they don't criticize you.
Do you think that's what this government is doing to the NPP folks?
Too much. I am of the view that it's not important at all. Because a man of Abronye's stature, you can't use the power of denial of bail and the rest of these communist inferior tactics, to submerge him from, declaring what he believes, is a state of affairs. It's an exercise in futility.
But that's what the courts are mandated to do when they are doing that. That's not the government. We can't link what the courts are doing to the government. Is that not the case?
You see, what the courts are doing are initiated by the government.
By the police. The police caused the arrest.
You cannot separate the police from the government. You see? Because one of the enforcement agencies of the government is the police. The police will ensure that governmental orders are carried out.
And governmental orders,
of course,
based on law.
Yeah. Even some of the orders will never be based on. That's how somebody feels. Somebody feels that you are insulting the president.
There's no law that says if you insult the president, you get arrested.
Well, it depends on the context, Like, for instance.
But if you threaten the president, you get arrested.
Well.
So that is based on law.
When is an empty threat? Where are you taking it? I will show you where power lies. Imagine a young girl trying to say that he will set herself against the powers of the state. It's laughable, is it not? So I am of the view that they shouldn't develop this hypersensitivity relative to free speech, because a time is going to come that they believe that they are above criticisms. And that is not democracy.
Do you think that is exactly what happened to your client, Kwabena AduBoahen?
In terms of
arrests, the manner in which he was arrested and all that?
It was pathetic. This Kwabena AduBoahen, I keep saying, was part and integral to the national security setup in the country. And my good man, if you want to arrest a national security couple, it's a phone call away. It's all that. Kwabena, there are some matters I'm concerning you that you need to come and answer in EOCO. And if you want to come, you may come with your lawyer. The time schedule is 10 o'clock. But if you believe that, let's show this young man where power lies. Let's get him arrested at the airport, put handcuffs on his hands, showcase him to the whole world that as if he's a common criminal. It's shameful to the one who is effecting the arrest, as if you have an axe to grind and we are not practicing due process. If we are practicing due process, you can invite anybody. Nobody is immune from arrest. A phone call away.
What is wrong with the manner in which he was arrested?
Was he running away? You know, the issues of handcuffs are like people who have the propensity to run away. Where was he going to?
But that's the discretion of the, arresting authorities.
It's a poor discretion of the one arresting. It's a brutal show of force and bravado, which is needless, because the man himself checked through the Kotoka International Airport. Is it the modus operandi of criminals? A decent man, national security couple, comes through this country, Kotoka International Airport. So why do you want to humiliate him by putting handcuffs on him? You talk about discretion, as if my will be done. Discretion should be grounded in law and decency. That the same way that you don't want to be treated, you shouldn't treat another. And I believe it was very disgraceful that the national security couple, should be arrested in a manner in which they treated him, put handcuffs on him, and then showcase to the whole world that he's been arrested.
And you've also been raising concerns about the bail approach, the process and all that. What is your key concern about that process itself?
You see, when somebody is arrested, the Constitution says that if the time and the period of arrest should exceed 48 hours, the law enforcement agency should send the individual to court unconditionally. But what is happening is that the law enforcement agency like EOCO will say that, can you go and bring 3 houses at Trasaco over an unproven matter? So if you say the figure that has been stolen is even 100 million Ghana cedi, it's unproven. But the underlying principle for bail is to say that, look, can you give some reasonable security so that when we need you for further investigation, you'll be able to provide it.
Yeah, so that reasonable security is what they put on the table based on the gravity of the case he finds himself in.
What is the gravity of the case on the terms of the one who arrested you? He puts that gravity on that case. So in his imaginary, if you like, a funny situation, he's saying that, look, what I'm investigating is worth 200 million. You go and look at it, and it's so anemic, you don't know how even they got the facts. So they go and assemble funny facts, and they say, okay, this is the basis why you should post bail in the sum of maybe 500 million. And then the person is unable to do it. And they know that it's so cruel and oppressive. The person will not meet the bail term. And the person will be in their cells for 8 days, 9 days. And they breach the Constitution with impunity. The Attorney General will not want to address EOCO that, look, you are flouting the Constitution. The Constitution behoves you to take the individual who has not made the bail condition to court. Because you shouldn't exceed 48 hours.
So his rights have been breached?
In serious dimension, that if they want to ventilate their position in court, they will secure compensation.
Is this something you are considering or he's considering?
Well, we are so engrossed in the issue of, now we are on bail, of the trial. And there are several outstanding matters we will deal with. For example, if you have the propensity to try a man in the media and bastardize him.
Who is trying who in the media?
The Attorney General did it with impunity.
He was updating the public. The matter was a matter of public interest.
About a man who is guilty and should come for plea bargaining. The Attorney General is a court of competent jurisdiction in the media space. where there's no, proof beyond reasonable doubt, and you fed them with how you feel about the case. And Joe Randolph didn't do that. Marietta Brew didn't do that. All the attorney generals never believed in the power of the press. They believe in the power of the court, where proof is beyond reasonable doubt. Now, when you defame a man, and it turns out that all that you said about him is false, how does it repair his image?
But at this stage, we are not at the end of the road yet. So
I'm saying that the defamation has been registered already. And what we are going through is not the way to go. That now the court is going to look into the matter, and then they find out that, look, all that you said about the man was false. But his right to go and seek damages for, defamation is still present and active. But we are so consumed with these matters, we will know what to do.
So you thought that the press statement made by the Attorney General on this case was unnecessary?
It was very unnecessary. In fact, it didn't sit well with the high office of an Attorney General. And the Attorney General is acutely aware that he has a constitutional role, Article 88, is a principal advisor to the government. And if the principal advisor to the government is violating the very Constitution, I'm afraid then rule of law is sitting upside down. It doesn't help Ghana.
How is the case going anyway?
Well, I don't want to do anything by way of self-praise. But you are the fourth estate of the realm. You follow the case critically. Some of the high points of the case you know already, and some of the proceedings have been, it's in the public space. But today, what is frightening for everybody to know, that there's what we call the prosecution witness. The prosecution witness is the individual going to aid the Attorney General to prove the case beyond reasonable doubt.
You're talking about Mildred Donko?
There's not Mildred Donko. There have been more serious things than Mildred Donko.
Okay.
And more serious thing is PW2. It is Eduama said national security has not lost 49.1 million on oath. We have not even brought AduBoahen for internal disciplinary committee meeting. So you are in your own enclave and your pigeonhole, and you are assuming that 49.1 million cedis is lost, in the national security space. It's false. She said all these things. So when you have, a prosecution witness, drumming home the innocence of the accused person, now you should tell.
That's why you're smiling.
You should you should tell how the case is going. Right now, I don't want to begin to run unnecessary commentary on that.
No, but you are a seasoned lawyer. You've dealt with high-profile cases over the decades, and so you should see the direction of this case. Are you winning the case?
Well, we should win the case, because at the end of the day, if you pay regard to even the disclosures that they are about to put across, the court has ordered that come and explain to us the purpose of
the transfers?
49.1 million, the purpose. So if you assume you are EOCO, and guess what? EOCO and the Attorney General has not fielded the national security couples who were functioning during AduBoahen's time. For them to say, we were the people who were doing the thinking of national security. And the 49.1 million was a rogue arrangement by AduBoahen under the guise of procuring a cyber defense system. And therefore, we will testify in your favor against him. Do you know the material witnesses in this case? One of them is a driver. They've not called the previous national security coordinator. They've not called Kandapa, the former minister for national security. So what kind of guesswork?
Were you expecting the prosecution to rely on those key people?
Now, without doubt. Then the case is too anemic and irretrievably bad.
Why anemic?
Because they are the people who should testify against AduBoahen and not EOCO. Because what does EOCO know about what is happening in national security? As we are talking now, this current national security operations, you think EOCO is privy to how the government submarine is functioning, and they know how they are treating the president, his travels, protection issues, what is happening in Boko, and the rest of it? You can't sit in your office and even second guess what Joy FM is doing. I can't second guess what you are doing. I don't know your finances. I can't sit in Zoachienko and begin to profile views.
But Joy FM is a private institution.
Yes.
You know, Signals Bureau is a state institution. So there is public interest.
And that's what I'm saying, that it is even serious because of how national security is not the graphic we read every morning. So therefore, if you want to say that, oh, you've delved into national security matters, at least much to be that desired, because I was expecting that those who are in the national security space are the material witnesses who should level allegations against Kwabena AduBoahen.
Situation is that your client created some BNC accounts that mirrored what the original system should have been, and monies were being siphoned or transferred through that system. What is your position on that accusation by the prosecution?
You see, the wisdom of the Court of Appeal is clear that they should come and explain the purpose of the cyber defense system and how it attaches to the 49.1 million.
They should be able to establish a link.
They should be able to establish a link, the purpose of that money. Because the theory of the prosecution is very funny, that Kwabena AduBoahen was powerful enough to have siphoned money from what they call the state BNC into an account that he created, which is called B.N.C. Communications Bureau Limited. And that was the receptacle of the crime. It has turned out that account is a national security special purpose account. At the instance of who? Chairman, not Kwabena AduBoahen. And guess what? In the account, you could see monies being transferred from that account back to the National Security Coordinator's account with Fidelity Bank. The criminal returned the money to the source of the theft. Absurdity of monstrous proportion. We cannot do that to ourselves. And why do you want to show?
So you are saying tonight that Kwabena AduBoahen, those monies paid through those accounts cannot be linked to him? Is that the point you're making?
It is not even at his instance. He didn't initiate the opening of the account. It was a national security coordinator.
Under his authority?
Yes, yes. No, he created the scenario of bringing advantage solutions in. You know, the national security can use even private entities to aid their work.
Right.
And then there's a clear letter to Advantage Solutions that opened this account in this bank. And that was what was done. It was not Kwabena AduBoahen who opened the account. And all the checks that were paid into the account were at the instance of Cheleme. The 49.1 million was paid into the account, not one go, 3 occasions, through the checks signed by Cheleme.
AduBoahen never signed those checks.
AduBoahen co-signed it. Yes.
So that makes him complicit, right?
How can he be complicit when he didn't open the account?
But he sat at the helm of affairs.
No.
He issued orders.
You see, he never issued any order. He didn't initiate the opening of the account. It was when Cheleme decided that he wanted to transfer money into his special operations account, that because the national security account at Fidelity has a signatory, one of the signatories, the National Security Coordinator, and is one of the signatories that said, come and sign this one also and put it in my account. So
and he signed.
He signed. Yes. So when he signed, it was not for his private benefit. It was a National Security Coordinator running that account. It's as simple as daylight. And I don't see why anybody...
What about those transfers we've heard that certain amount of monies were transferred to his wife's account and back and forth and all that?
You see, people are not right in their thinking concerning national security matters. So now, if you saw an account and there's a decoy, transfer this money to Atachia, but the intent of using Atachia's name is to transfer it to another person of high political sensitivity. So how do you sit in your bedroom and interpret the spending?
Why would you do that? Why don't you transfer the money straight to Atachia?
Because national security does not do that. National security does not expose itself. So to you, there's a transfer to AC, but to national security, it's a decoy for Mansa to be the beneficiary.
And why would the decoy be the wife of the man who sits at the helm of affairs?
Because she's been sworn in by national security, and national security will function through confidentiality and trust and secrecy. Now, even if you breed a secrecy, it could be a subject matter of your prosecution. So national security does not function by anybody. So if national security believes that if we repose sufficient confidence in Kwabena AduBoahen and is a couple, and let's find people in a circle who we can trust to aid our operations, national security will do that. And the pattern is not new.
Who makes that decision of selecting a decoy?
National security coordinator. And not Kwabena
Are there
AduBoahen.
files that we can look through and see a decision was taken at this point in time that the wife of Kwabena AduBoahen should serve this purpose and this money should be transferred to him?
At least we know of one letter to that effect. But that's why the Court of Appeal, the three wise people have said they should bring the files in the national security space so that they'll confirm what you are surmising.
Which I think you are so much happy about.
I'm very happy about it.
Why?
Because then you can't doctor evidence. You can't sit down there and put together a theory for the consumption of the press. Because the documents are not supposed to be for entertainment value. The documents are supposed to prove beyond reasonable doubt your case. So that if the documents are not consistent with what we are trying to project as crime, the case will collapse. So that is why there's no reason why anybody should hide anything from the court. That is why we call it the disclosures. And the disclosures are intended that you don't surprise the defense and the documents you want to use to prove the case are before the court. In a very serious environment, if you withheld 88 pages of a document, you understand, that is concealment of evidence, which is contrary to section 55 of the Evidence Act. It's even a criminal offense to withhold or conceal critical documents.
Who is withholding it?
The Attorney General, of course. Yes, because that is why the Court of Appeal said, they should provide it now, that they cannot take 88 pages out of a document when the freedom of the individual is at stake. Because what you're supposed to do, the Attorney General is not a persecutor. The Attorney General should not glory that the innocent goes to jail. So even if they are exculpatory evidence, what is exculpatory evidence? Evidence that are consistent with the innocence of the accused person. And the Attorney General sees them, the Attorney General should make it available to the court. In fact, it will be dangerously unprofessional for the Attorney General to hide documents that are consistent with the innocence of an accused person.
What role does that particular 88 pages in?
Okay, Abusia, we ne ensema a court Kwabena AduBoahen. The court cases no, and I see no, appeals court a day a honsem asan so about order the likes of Attorney General say produce the enough evidence na fair trial no. And because you better must some of the penny cocotiza and some way at the money,